5 seconds to go. Start. Although Chittaranjan and Meena deposed equivocally that Prativa had a love affair with Sheetal and he proposed her to marry, which she refused, the same does not in any manner link Sheetal to the offence. The fact of having an affair has been denied by Sheetal, although Ratna Chaudhary PW10 and Aradhana PW11 had categorically corroborated this piece of evidence of Chittaranjan and Meena that she had an affair with Sheetal. PW14 had also stated that he heard that Prativa had an affair with some person named Das, but he could not identify Sheetal to that Das, and the principal of that school, Jitendra Kumar Singh PW12, also only deposed that he heard that Prativa had an affair with Sheetal. But not a single witness except Chittaranjan and Meena deposed that Sheetal proposed to marry Prativa and the latter refused. Not even the brother and sister of Prativa deposed to that effect. There is hardly any whisper that due to the refusal of his proposal, Sheetal seeded a grudge against Prativa and so he had a motive to commit her murder. Although it is the evidence of Binay Kalita PW21 that he seized two mobile handsets from Sheetal while Exhibit 8 and corroborated that piece of evidence, but neither Binay nor Kripa deposed that one of those handsets belonged to Prativa. Rather, it is the evidence of Binay that he did not find the mobile of Prativa. Sheetal could have possessed as many as mobile handsets as he desired to possess. It does not in any manner point the finger of guilt to him. Besides, PW21 in his cross examination had deposed that he arrested Sheetal on the basis of call records of mobile phone number 97061244495, and it is the evidence of PW8 that this number was taken by him, which he gave to Prativa for use as per her request. But there is no evidence that this SIM card was inserted in either mobile phones seized from Sheetal White Exhibit 8, and PW9 also categorically deposed that she did not know which mobile handset was used to send messages from the SIM card used by Prativa. Besides, the prosecution had neither produced the call records nor proved the fact that one of those handsets was used for sending messages by inserting Prativa's SIM card. As Prativa had an affair with Sheetal, it was very natural for her to talk over mobile with Sheetal, and the fact that she used to talk over mobile has also been clarified by the witnesses. Therefore, there is no concrete evidence to link Sheetal for sending the messages to the family members of Prativa after her missing. So far, the matching of handwriting of Sheetal is concerned, it is the evidence of PW17 that he matched the sample handwritings with the questioned handwritings after collecting the samples. Wide Exhibit 10 letter by which the samples containing capital letters purportedly written by Sheetal was obtained. However, Sheetal denied giving such samples in his statement under section 313 of the Code of Criminal Procedure. Besides, the officer in whose presence such samples were taken and the officer who forwarded the same to him were not also examined by the prosecution. In absence of such sporting evidence, it is totally unsafe to rely the opinion of the handwriting expert and base a conviction on such opinion alone. Even if the opinion is taken into reliance, then also it does not complete the missing link amongst the circumstances to relate Sheetal to the offence. Atul PW8 had deposed that Sheetal made an extrajudicial confession before him and Chandan that he committed murder of Pratibha while he was taken by them along with the police at Golpara, and he also led them to the place where the dead body was discovered. He also deposed that on being so led by Sheetal, police recovered the articles of Pratibha. But Chandan had not corroborated the evidence of Atul to the effect that Sheetal confessed about his guilt and made such an extrajudicial confession. Besides, such a confession made before strangers, that too in presence of police official, is not admissible in evidence and hence cannot form the basis of conviction. So far, disclosure statement Exhibit 15 of Sheetal is concerned regarding the recovery of the vanity bag of Kavita, that too is also not sufficiently reliable as the same was found in open area under a culvert close to the place where the dead body of Kavita was discovered and was accessible by any person. It was not such a secret place that only Sheetal could have the knowledge and none else. Therefore, such a disclosure statement cannot form the basis of conviction where the other circumstances are not proved beyond reasonable doubt. It is the evidence of Chittaranjan and Meena that Pratibha went to school on the fateful day, saying that she would go to New Delhi with Anuradha, which was out and out false, as Anuradha denied such an event. Even Pratul denied that he told Meena that he dropped both Pratibha and Anuradha at the airport, although both Chittaranjan and Meena deposed so. Rather, Pratul said that he saw Pratibha in school and she requested him to bring an auto rickshaw, and he was instructed by her to inform her family that she was going to the temple after the school hours, which he accordingly did. Not a single witness had deposed that he saw Sheetal going with Pratibha. Therefore, there is no evidence that Sheetal took her with him. Sheetal was neither noticed by any person with Pratibha later on also, and he was only arrested on the basis of call records of Sheetal only. Although it is the evidence that Pratibha had an affair with Sheetal, but there is no evidence that Sheetal incubated some kind of grudge against her, and there was no motive at all for him to commit such an offence. Besides, the disclosure statement is also doubtful, and the so-called extrajudicial confession made before Chandan and Atul in presence of police is also not admissible in evidence. In view of the above, the circumstances against Sheetal have not been proved beyond reasonable doubt, and the chain of circumstances is also not complete. It is no more res integra that, in a case based on circumstantial evidence, the independent facts and circumstances must be proved beyond reasonable doubt, and the chain connecting those circumstances must be completed without any break, and such chain of circumstances must point the finger of guilt to the accused only and none else. In the instant case, the same is lacking, and hence it is held that the prosecution has failed to prove the case against Sheetal beyond reasonable doubt. As such, the appeal has no merit and accordingly dismissed. Stop.